Hello everyone, I'm Professor Paul Carrier and I would like to provide a little bit of background information that should help you to understand the homework for Class 1 in Contracts 1. To begin, we're in Contracts 1 and the highlights that I'd like to cover today deal with the offer, but what I'd like to make you understand is that we are beginning the entire course for the first 5 or so weeks on issues of formation. What is necessary to form a contract? And the main elements of a contract, or of forming a contract, are the offer, which is what we cover today, acceptance, which we cover next week and I believe the following, consideration, which we'll cover in the future, and mutuality, or a meeting of the minds with regard to the particular bargain at issue. There are certain other elements that are typically implicit in contract formation, and you do not need to worry about those unless the facts of a particular case implicate those issues. For example, you can assume when you see facts of a contract in formation that the people involved are old enough to make a contract. If you see, however, that someone is under the age of 18 or 16, that might be one of these implicit elements, which is the fact that the person has legal capacity to enter into a contract. But with those implicit ones, you do not need to worry about those unless the facts implicate. Therefore, we go back to the main four, which you need to memorize. In formation, you've got the offer, the acceptance, consideration, and mutuality. With regard to formation, the need is to find out whether or not there is an agreement that the law can enforce. And that's why we check for formation with these primary elements. If you have these elements, there is a contract, there is an agreement, and then the parties can go about enforcing it, enforcing their rights and fulfilling their duties. If some of these are missing, or one major element of these contract formation requirements is missing, then you do not have a contract, and the parties are simply in a negotiation phase. Again, we're starting with formation for the first few weeks of Contracts 1. Later, we will address other issues like the rights and duties of a contract, which is different than formation. We will deal with breaches, where a contract is formed but somebody makes a mistake. We will deal with damages later in this term. When someone breaches a contract and doesn't fulfill a duty, what are your rights? What can you get in return? And even next term in Contracts 2, we will cover defenses. But again, these formation issues we cover right now are where all contracts law needs to begin, and we will be covering these for the next 4 to 6 weeks. Beginning with the offer. The first component of formation is the offer, and by way of highlight, this is what we're going to do with today's material. This week's material. First, we need to determine the intent. Did a party intend to enter into a bargain, and did the other party agree to enter into that contract, that bargain with the other person? We are going to ask ourselves, from whose point of view an offer is gauged. Is it what the subjective mind of the offeror is thinking? Or is it, in fact, and this is a little bit of foreshadowing, is it what the person listening to an offer believes when he or she hears or reads its presentation? We will be looking at facts in the first case to determine whether there is a joke, and if someone's joking, for example, I offer to sell you my car for $5, well, I am joking and I don't form that intent. Question is, though, is not necessarily if I was serious, but if the recipient would think that I was serious. And in regard to that, if you're looking for the rule with regard to the intent of how an offer is delivered, you would look at page 7 of today's materials. I might be able to point out the specific portion via video cut-in. We're also going to cover things that are not offers. Puffery. It's the best car of the world. It's the best pizza oven ever invented. Those are not the kind of specific promises that can lead to damages. It's more of a sales trick, and the term of art in contracts is puffing or puffery. And if someone says something that's overblown, it's not intended to be binding, it's intended to advertise and make things sound rosy, but you can't sue on that particular promise. Social contracts, typically, are not binding agreements. They are not offers. I offer to have you come to dinner next week? If you don't come to dinner, may I sue you? Probably not. Because social contracts typically do not have the intent for them to be binding and for the other side to accept, and upon accepting, be liable for damages. By the way, the puffery issue is covered on page 8. Social contracts are covered on page 9 in a note. Preliminary negotiations are not yet offers. I am thinking of selling you my car. Is not an offer. I will sell you my car for $3,000. Is probably an offer, and you should be able to see the difference. Statements of opinion or intent. I will be the best lawyer to represent you for the perfect resolution to your case. If that case is lost, may you sue me other than malpractice. May you sue me for my promise of my performance. And the answer is no. I am a great lawyer. I can do a great job for you. You can't get better representation. Those are statements of opinion or intent which don't reach the level of a binding offer. If I had said, I promise you, you will not do more than 9 years in jail, I can guarantee that result. Now, perhaps, we have the proper intent from the delivery for it to be a binding offer that you may accept, and if I fail to keep you 9 years or under, you could sue me on contract. Advertisements, ads, solicitations are typically not offers. Come on down. Thousands of fur coats for sale. Best prices ever. Those are typically advertisements which are not specific enough to indicate the intent for me to sell a specific coat at a specific price to a specific person. There are exceptions where the terms are specific enough, and we will cover that in the case in just a minute. Another example, and it would be where someone draws up an agreement in writing or even orally, but then there's a statement to the effect that a written agreement is to follow. In other words, I agree, I think we agree, but I need to look at the final version in writing before I bind myself. And so when you have a written contract to follow situation, there is probably not the kind of intent necessary for an offer to have been made and for a binding arrangement to have been cemented. Today's material covers several things that are offers. I just covered 4 or 5 things that are not offers. Puffery, social contracts, preliminary negotiations, statements of opinion or intent, ads or solicitations, typically written contracts to follow. Things that are contracts, where there is an intent to enter into an agreement and most of the major terms are clear, known, and understood by both parties. And when you see those, you have an offer, and then you'll have a corresponding acceptance, which we will cover next week. Again, we learned with the offer, it's being judged by the listener, the offeree, not the person making the offer. There are 3 kinds of contracts that are mentioned on page 14, which may be a little bit advanced to cover at this point, and so we might cover it in further detail later in the course, but they can be express, where I write to you an offer. It could be implied in fact. I point to the grapes. I point to your wallet. I point to $2. You hand me the $2. The facts, without my words, spoken or written, indicate that I am offering you to sell the grapes to you. And so that would be an implied in fact contract based on the facts and circumstances that are happening in a particular situation. There are a few cases where a contract, an offer, and acceptance and all the other components can be implied by law. And that's something that hopefully will be addressed by the time we finish with contracts too. One final thing that I'd like to point out now, and you will hear this again. Who does this determines whether a contract has been formed? Who determines what are the terms in the agreement and what are things that are not in the agreement? Is it the judge? Or is it a jury? Is it the fact finder who's determining whether or not she ran the red light or she didn't run the red light? Or is it a judge determining what is and is not proper based on the parties' writings and the parties' performances? If you take a look at page 22, and I'll try to point it out with a cut-in, you'll see that it appears that it is the court and not the jury that decides formation issues. So it would be the judge deciding whether I had the intent to offer something, and I am asking you, I am allowing you to accept it. And it would not be a jury sitting in the jury box. It would be the judge. A jury for contracts issues can be used for other things, which I will cover later in the course. Okay, now to today's material specifically. The first case, Lucy versus Zamer, is a case that deals with the offer and how the offer is to be communicated, how it is to be gauged. Is it gauged by a jokester crossing his fingers? I'll sell you the moon for $10. No. It is actually the perception of the other party, within reason. If I say something, even if I'm joking, and the other party recipient, the offeree, does not know what my intent is, and believes my intent to be pure and honest to enter into a bargain, then we have a binding agreement. And so what you see in Lucy versus Zamer is a significant amount of joking, jesting, and teasing, which begins on page 2, goes into page 3, even goes as far as page 4. Later, we start seeing evidence where it may have been serious. What did the waitress think? What did the offeree recipient of that information think? And by the time you get to page 7, in the middle of the page, you will see that the mental assent of the parties is not requisite for formation. What that means is you don't need to know the parties' specific intent in their own minds. You look at how it's perceived externally by a third party. And so, words or acts that may be in jest, but that look to the other party that they are made in good faith and with the intent to enter into a bargain will control the day. And that will be determined to be a valid offer. The notion with regard to social contracts not being the type of offer with an intent to be bound, you can see a note on page 9 and spilling onto page 10 that explains it in more detail. Stepp versus Freeman on page 10 is a case that deals with an oral agreement where parties talked enough and had enough factual performance for a fact finder, here a judge, to determine whether or not an agreement had been formed with an offer and an acceptance and all the other elements. And it is that case, in fact, where the court mentions the 3 different ways where a contract may be formed, and that begins on the top of page 14, and I mentioned this in the introduction. It can be expressed by words or by written language. It could be implied in fact by circumstances, or it could be implied in law. In certain cases, the law will impose the existence of a contract to further some important public policy. Again, we are still very much in the early stages of contract formation, which is also mentioned in the middle of page 16 in the note. We get to the offer itself. And this is a case I asked for my students to skim, not to read. But if you see the PFT Roberson case on page 17, the important thing about that case is where the parties had quite a few ideas, agreements, thoughts, beliefs, commonality with regard to a large contractual relationship. But the intent was, we agree on all of these, and if we don't agree on all of these, we do not have a contract yet. You can't take 4 of the 10 things we've been discussing and make those binding. If you accept all 10, we have an agreement. If you try to take only 4, we do not have an agreement. And that was the importance of the PFT Roberson case. Okay. And that dealt with, in large part, various emails going back and forth with the intent to determine what is and is not part of the contract. And of course, in the middle of page 20, the court majority in that area mentions that there is no contract unless the entire agreement is made, if that's the intent. There might, at this point, be simply preliminary negotiations. That it's a question for the jury as that it's a question for the court and not the jury, is covered in the middle of page 21. Another thing that's typically not an offer, leading to the ability to accept and to form a contract, are statements of opinion or intention. Those are more advertising, more hopefulness, and not the kind of thing that is intended to be a binding obligation or to create a binding set of obligations. Page 22 as well. Other things that typically are not offers are ads or solicitations. Best tires, best prices, that is a description that is basically intended or it's interpreted to be an offer to enter into negotiations. Come into my store so I can show you the tires, I can show you the prices, and then we can determine which ones are for you and what price I can afford to sell them at. So an ad in a newspaper typically is not an offer that can be accepted. It is a mechanism by which a seller will try to entice a buyer to come in and to begin the negotiations. And you find that information on pages 22, well, basically on 22. And the case that deals with that particular issue is on page 23, the Lefkowitz case. There was an ad in a newspaper offering certain items of clothing at a very, very low price, first come, first served, and in a few cases, the advertisement was not clear enough. The terms of the bargain were not clear enough for there have been an intent to offer. And therefore, someone running in first and yelling, I accept, here's my money, was not appropriate. It was basically asking that party to come in, look at things, and then make the offer. However, there was one item where there was sufficient information. First person to come in that day, we're selling only 3, and it's not an unlimited amount of sale, and this is the price definite. And that was held to be, from an advertisement, clear enough, specific enough, to constitute an intent to enter into a bargain. And so the person who ran into that Greater Minneapolis surplus store on the sale day was able to accept and pay for several items, but on other items, they were held to be simply these offers to enter into negotiations, and that person left unsatisfied with regard to those other items. So a key there is the level of specificity of what the alleged offer is. If it's very clear, it's very limited, and the person to whom it's offered is also clear, then perhaps an advertisement in a newspaper is enough. Example, we have 4 tires we'll sell for $1 a piece on Saturday to the first person through the door, but only 4, quantities limited. That is probably enough to constitute an offer, and the first person there with $4 would be able to enforce that contract. And Continental Laboratories is an example of a contract or contractual negotiations that came very close to a formed agreement. However, there was within that set of negotiations the statement that the written contract was to follow. What that means is that the person who wanted that clause in the contract, wanted or made that part of the negotiations, needed to see what was in writing to take one last look at it. And if you still plan to look at it before you accept it, or if you still plan to look at it before you sign it off as your offer, then you're at a preliminary phase and not at the final phase where you can determine the intent to be bound. And so with written contract to follow, typically you will find that there is no offer yet, certainly no formed contract. With regard to the rules, you'll find the rules in the middle of page 29. The analysis follows on to pages 30 and 31. And, ladies and gentlemen, that ends today's prequel into the import of the first course in Contracts 1 at Western Michigan University Thomas M. Cooley Law School with Professor Carrier. There will be some information on my Twen page, which you can access as a Cooley Law student, and I look forward to seeing you on Monday. Thank you.